Now, can I call on now I just want to get your title right, Justice Blanchard, Justice Peter Blanchard. Now, of course, he is on the Supreme Court, and most importantly, he is here. And sir, I'm just a little confused by what's written here as to whether or not you were redesignated a Knight Companion of that order in 2009. So I'm just wondering what that means in terms of your title. So what is the right thing to address you by? No, that's fine. Well, anyway, Justice Peter Blanchard is, of course, one of the most senior judges in New Zealand. He was appointed to the Court of Appeal in 1996. He was subsequently appointed to the Supreme Court in January 2004. His career on the bench follows roles as a member of the Law Commission, and of course the Honourable Dr. Wayne Mapp is now a member of the Law Commission, and we are also going to hear from Sir Grant Hammond this afternoon, who is the current president. He has also been a partner in the law firm Simpson Grierson. In 2005, Justice Blanchard was awarded the Distinguished Companion of New Zealand Order of Merit for services to the judiciary. Peter has said to me that if there is an issue which concerns property or pipes and wires, then he is often seen as the expert in that area. So we're looking forward to him addressing us, and he is going to talk about litigation as a tool. It is often a tool of last resort. I'm sure many of you here in this room have had experience of having to consider whether or not to use litigation, and we look forward to what you have to say to us on that subject.
Thank you, Mai. Good afternoon, everyone. My topic this afternoon, and I've been told to stick to my script, is why litigation should be a public law tool of last resort. You will notice that the way this is posed is loaded to ensure that I bring to it a negative perception. I didn't choose the topic, but if I disagreed with the bias, I would have protested. In fact, I entirely agree. Indeed, it's only a subset of a wider point. All litigation should be a tool of last resort, a proposition with which I doubt any of you will disagree, unless you're lawyers. Litigation of any kind is potentially very time-consuming and expensive. It will likely distract you, or in the case of lawyers, your client, from more fulfilling and possibly more lucrative engagement with your role in business or administrative life. Litigation has grown ever more complicated during my time in the law, and sometimes it seems that even the simplest case risks getting bogged down in procedural and substantive complexities. Whether you're trying to run a business or a government agency, you simply don't want that kind of distraction. Litigation is also likely to be very expensive. You don't need me to tell you that lawyers don't come cheaply. You may find that you end up paying out far more than the dispute was worth, especially if you take your eye off the ball, namely the probable outcome in economic terms, and become bogged down fighting over whether there's some form of liability. This is a very common mistake which lawyers make in advising their clients. Always think about the outcome and whether it's worth the fight. Outcomes in court are notoriously unpredictable, and perhaps even more so if the lower court decision is followed by an appeal, or heaven forbid, if the case goes to the Supreme Court. Most of you will be familiar with cases which have completely changed their shape or focus in an appeal court and finally turned on something which was not predicted when the writ was issued. The next fundamental point, and I'm really only reminding you of things that you must know already, is that litigation will usually, if not promptly settled, permanently damage any ongoing relationship you may hope to enjoy with the party on the other side. Again, you need to make a cost-benefit analysis. Is the potential gain from winning the litigation worth more to you overall than the loss of the ongoing business opportunity or the connection in the case of a claim relating to a governmental agency? Even if it's theoretically possible for the parties to get together after having their scrap in court, that will often be ruled out by the distrust and dislike between personalities on each side, which emerges as the result of the court process. If your counsel has to put it to the other side's witness, a key player in their relationship, however gently, that he or she is telling porkies, it's going to be very hard to resurrect the relationship. This may be all the more difficult, and there may be general embarrassment in any event, if the proceeding when issued or heard attracts the attention of the news media. And that brings me to the particular perils of litigation in a public law context. First, and perhaps most obviously, if you're fighting a public body, you're fighting somebody who's likely to have a deep pocket. That's certainly true in a private law context. Think of how often you've seen the Crown bringing and appealing strikeout decisions when sued in negligence. The same tactic may not be employed in public law, but there may be equivalents designed to slow you down, make things more expensive, and burn you off. From the public body's point of view, there's going to be expense, of course, which may be hard to justify in a time of economic stringency, and even more pertinently, the problem of distraction in having to brief lawyers, trawl through files for the purposes of discovery, complete affidavits, which may be dozens of pages long, and prepare for and undergo trial. For a public defendant, and a government agency is usually the defendant, the publicity may be particularly unfortunate and may even attract the attention of the Auditor General or a select committee. From the plaintiff's point of view, it must never be forgotten that in a public law claim, the ability to seek damages exists only in the exceptional case, notably under the New Zealand Bill of Rights Act 1990. But even there, the level of damages which may be awarded will be quite low following the Supreme Court's decision in Taunoa. Where you're bringing an administrative law claim, it will be rare that you're able to get an order directing the public body to do something, the old writ of mandamus. Much more commonly, the relief you'll be able to obtain, if successful, will be the quashing of a decision and a direction that the public body must begin the decision-making process afresh and conduct itself differently. But of course, the risk remains that it will still come to exactly the same decision adverse to your interests. So in the end, you may achieve nothing other than a lower bank balance for both sides. You need to remember that often a public body will not feel able to settle the claim, and that can result in litigation which is unfortunate for both sides. Obviously, if you do issue a proceeding, you'll want to try to persuade the government agency that there's a way of sorting out the problem short of actually going to court. This used to be a great difficulty for taxpayers in combat with the Inland Revenue Department, until the Court of Appeal pointed out back in the 1990s that the Commissioner did have and should use a statutory authority to settle cases. The result of that has been that the Commissioner has been able to be much more selective about what cases to take to court and on which to obtain rulings from a judge. And I'm told that overall, as the Court of Appeal actually predicted, he has as a consequence been able to obtain greater revenues. Previously, he was fighting every case and losing quite a few of them. And so it was in his interests, though the Commissioner of the time took rather a lot of persuading, to engage in settlement negotiations. And so it must be for other government agencies in some cases. You need to consider also, looking at the matter from a plaintiff's point of view, whether the agency you're suing may actually welcome the case and have it in mind to take it right through to the Supreme Court, if necessary, in order to obtain definitive advice about its legal position. There's nothing illegitimate in a government agency being of that mind. But from the plaintiff's perspective, it will mean that it'll be a long and expensive fight. And remember that court costs, even if you win, give you back only part of your expenditure. So you need to think about how much is at stake for the government agency and gauge its likely reaction when served with proceedings. Will it say, this is what we've been waiting for and we can find out what the law is? Or will it say, whatever the law may be, this is not very important to us and we'll look to settle as soon as possible? If the answer is the former, do you want to be the guinea pig? One final thought relates to the appeal process. You have to bear firmly in mind on both sides that there may be constraints on the nature of appeal that you can bring from the original decision, such as exist for an appeal to the High Court from the Environment Court. The appeal may be restricted to questions of law, and it's sometimes quite difficult to say whether a particular issue does or does not involve a point of law. Lawyers are actually quite good at kidding themselves that matters which are essentially factual somehow involve a question of law if the point can be cast in a particular way. They're usually unsuccessful, but it costs a lot of money to disabuse them of that notion. Now, I'm at the end of my time, and as I've foreshadowed, what I've been saying has been relentlessly negative in terms of my brief. There will, of course, be many situations where resort to a public law litigation remedy is a necessary and justifiable means, but be warned. Thank you.